Okay, this question asked the landlord served a 60-day notice stating that I guess the landlord needs to move back into the rental unit. This tenant has been living here for 7 years. Want to know like what the deal is, what their rights are. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, subscribe to our videos. Now, this question is always going to depend upon if the landlord is subject to a local just cause requirement under their local ordinance, if they're subject to the Tenants Protection Act, or if they're not subject to the Tenants Protection Act of 2019. So the simple answer is for exempt landlords, they're not subject to a local just cause ordinance or the Tenants Protection Act of 2019. If the tenant has lived there longer than 1 year, they're only entitled to a 60-day notice. Okay, these landlords do not need to provide just cause under the Tenants Protection Act or any other law. Okay, under state law, they can give a 60-day notice. They can give it for any legal reason but an illegal reason. Examples like if you're unlawfully discriminating against someone for their like race, color, nationality, that type of deal. If the sole purpose was to issue a notice because, hey, you're you're not a U.S. citizen. Okay, that would be off limits. Okay, but generally speaking, that landlord could issue the notice to be able to move in. Okay, they don't even have to specify that reason. Okay, now let me cover Tenants Protection Act of 2019. If this landlord is subject to the Tenants Protection Act of 2019, let's say they're apartment owner, let's say they don't have the proper requisite disclosures of the Tenants Protection Act and their tenancy, that type of deal, then there are going to be a lot of conditions. Okay, so first off, to qualify under the Civil Code Section 1946.2 subdivision B2A, which is the owner occupancy or their qualified relatives to move in, terminating the tenancy for that reason, it's going to have to be the owner, their spouse, domestic partner, or first degree relative, such as a child, parent, grandchild. Okay, if they're terminating the tenancy for one of those people to move in, that would initially qualify. However, there's a couple other nuances too, such as if the tenancy started on or after July 1, 2020 or July 1, 2022 for a mobile home, the lease agreement has to allow for a unilateral termination of tenancy. Okay, if it doesn't have that provision in your tenancy, then the tenant would have to consent to termination of the tenancy, or you would have to somehow lawfully add that term of tenancy into your agreement. Okay, that's a subject for a different video. Okay, then if we get beyond that step, okay, the landlord has a lot of notice requirements. Okay, they're going to have to specify in their notice to vacate that that whoever the qualified person that's going to move in, they're going to have to specify that information. They're going to have to disclose specific information, including the tenant could ask for confidential information to prove the relationship of the person moving in. Let's say I say my son's going to move into the house, that type of deal. Well, the notice says, I have to provide that information upon request. So possibly a birth certificate, for example, listing me as the father. That might be, you might have to give that to your tenant, that type of deal. The owner or whoever's going to move in needs to move in within 90 days after the tenant moves out. Okay, and they have to use it as their primary residence. Okay, the law says, I believe, let me look in here, I think it says primary residence, meaning you got to live there and you got to live there for 12 consecutive months or greater. Okay, 365 days or more, basically. Okay, those are the new requirements under the law. Also, there's some ownership interest requirements as well too, such as you have to have at least a 25% ownership interest or greater in the property. There are some exceptions for properties that are owned by families or revocable trusts. Not going to get into those details, but you can't be like a 1% owner unless you're like related to, you own the property with your family, that type of deal. So the legislature was trying to cut down on some of these types of owner move-in evictions. Okay, and then the biggest one I see a lot is, and it's in the Tenants Protection Act as well too, is you can't have a vacant unit of same or similar size that person is going to move into. So let's say you have an apartment complex, they're all like 2 bedroom 1 baths. Okay, and you got a vacancy open for a 2-bedroom, 1 bath that you're going to terminate this tenancy for, well, you're not going to be able to do that under the law. Also, too, the qualified owner or relative can't be already living on the property at the time. Okay, and this is the kind of kibosh the legislature wants to make it so, hey, the owner's not using this as a pretext to get someone out lawfully. Okay, so they can't live there at the property currently. Okay, so those are some of the requirements. There are a lot of other nuances under the TPA, and also your local ordinances they don't necessarily follow the Tenants Protection Act if they do allow for owner move-in as well. So you're gonna have to check your local regulations and ordinances to comply with those requirements. So that's owner move-in in a nutshell here. If you're contemplating doing an owner move-in eviction and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. Try to answer them to the best of my ability. Until next time, folks, talk to you then. See ya.